Hi, I'm Greg Dell here with attorney Alex Palamara. And Alex, I want to talk to you about Reliance Standard ERISA disability appeals. And the reason I say ERISA is because I'd say 99% of the long-term disability appeals we do with Reliance are ERISA because they write group disability and policies, and people who get the Reliance policy have it as an employee benefit. So we've handled hundreds of claims against Reliance Standard, and I kind of wanted to do in this video a how-to kind of tips for people who need to file an appeal so that they have an understanding of what's involved in filing an appeal and why it's in their best interest to have a lawyer help them and what the consequences are of doing the appeal on your own and then getting a lawyer later. So the first thing is that why is it so important to submit a strong appeal right now?
Your appeal is the last opportunity to strengthen your claim for a lawsuit. Once Reliance Standard denies your appeal, you cannot submit any more information into your claim. So what I'm saying is, once they issue a final denial, that information that's in the claim vault at the time of the final denial is the information that's going to be presented to the judge. Let's just say there's medical documentation of an MRI or whatever testing that you had done, but that you did not submit with your appeal prior to the final denial. The judge will never see that information. So your appeal the purpose of an appeal is twofold. One, to get you back on claim, and two, to strengthen your case for the potential lawsuit that's coming down the road.
Okay, so if you submit an appeal and the disability company makes a decision and the next day the claimant loses their leg, is the court going to be able to consider that?
Never. I mean, you get hit by a bus, become a paraplegic, the judge will never be able to consider that information.
Okay, so that is highly unusual in any other area of the law because you have to get every single thing in or it's never going to be considered. You know, the other thing that we do that's unique is when we send our request, person gets denied, they hire us, we request a claim file. The claim file is every single thing that Reliance Standard relied upon to deny the claim. They have to give it to us. That's one positive of ERISA because in other lawsuits we spend a year litigating through what's called interrogatories, request for production, request for admission, send us this, send us that. Finally we get everything. Here we get it all within 3 weeks.
Correct.
Right? You get this claim file now. What's the first thing that's most important in the preparation of an appeal?
Well, most claim files can be anywhere from 500 to thousands upon thousands of pages. So you're looking for a needle in a haystack, and the most important thing that you're looking for are the reviews that Reliance Standard conducted on your claim. Because what they're hanging their hat on to deny your claim are these reviews. Sometimes they're independent physician reviews where an independent physician conducts a paper review, or essentially they look at the medical records of your claim and they give an opinion as to whether you're disabled or not. Sometimes it's the report from an independent medical examination or a functional capacity evaluation. But more often than not, what they typically do is they rely upon these quote-unquote independent physician reviews. And the first thing you want to do is locate these reviews. They're anywhere from 3 to 10 pages long on average. And if the claim file is 1,000 pages, you have to file that needle in the haystack.
Okay. Why is the medical reviews done by the insurance company your starting point?
Because again, that's what they're hanging their hat on to deny your claim. And you want to find these reviews so that you can literally poke holes in the reviews, find issues with issues with their conclusions, issues with the medical documentation that they're citing to, or medical documentation that they're overlooking.
Okay, so we get the medical reviews. What we have to do then is analyze their medical reviews, analyze the medical records that are already in your file that have been sent, and then we get together and we strategize as to what additional medical evidence can we obtain that is going to convince this disability company that you're disabled. And the way we do that is, number one, from our experience of having handled thousands of these claims, we know for almost every medical condition what the additional medical support is. The other thing we do is we take the medical file reviews that you were just discussing and we provide them to either your treating physicians to review and opine upon, or we'll go out to consulting medical experts that we've worked with all over the country and say, here are the medical records of our client, here's the medical reviews from the company, what do you suggest is missing here, and what is the best way for us to attack this to prove undisputably that our client is disabled, has restrictions and limitations as a result of that medical condition. Talk about our specialty in working with attending physicians and other experts to obtain a unique attending physician statement from a treating doctor.
Well, in most cases, we draft a specific attending physician statement that's specific to our client's disabling condition and specific to our client themselves. So we go out there and we write a few-page report of questions that we present to the treating physician. We will get your physician on the phone with us. We'll explain to them the situation. Sometimes they wish for us to send a fax or a letter to them. So we'll put together a 1 or 2 page cover letter explaining this whole situation, what the definition of disability is, what the insurance company has said. We'll provide the review that the insurance company conducted on your claim, and we'll have very general questions or very kind of basic questions that your doctor can easily answer and give support for your claim. So we're going to go out of our way to make sure that your doctor not only speaks to us, but responds and fills out that attending physician statement that we've drafted for him or her.
Okay, so the first most important thing you got to do is get the appropriate medical support and address it in a manner where you are making your medical condition accepted by the insurance company. The next thing, which is rarely done by the insurance company, is presenting the occupation. And how important is it in your appeals in building up what the occupation is based upon the definition of disability in that person's policy?
Well, what the insurance companies love to do is they like to take let's just say you are a driver, and they don't get very specific. They go to the Dictionary of Occupational Titles, say, hey, you were a driver. The driver says, the Dictionary of Occupational Titles says, oh, it's a sedentary job. You only sit all day. Well, there's different levels of driving. You can be a delivery driver where you're carrying things out of the back of a truck, which is a very heavy level job. So they kind of dumb it down to the point where they're kind of dumbing down your occupation and overlooking many requirements that your occupation has. So sometimes we'll work with a vocational expert to actually explain the requirements of your job so that when we file the appeal, the insurance company can no longer dumb down your occupation to make it seem like it's a lesser job than it actually is.
Right, and then the other thing we'll do is we'll go to great lengths to have work on what's called a personal statement / occupational description to really go through a day in the life of your particular job. You don't just go to work if you had a sedentary job, which is like a desk job, and just sit there and do nothing. Obviously, you have qualifications and experience for that job. And if you're having limitations or pain or difficulty multitasking or focusing or any of those things, you can't do that. And we have to portray to the disability company that your job is far more than just this sedentary task.
Right. The Reliance Standard loves to deny claims saying, oh, look, your doctor said or our doctor said you can sit for 8 hours a day. But there's more to a sedentary job than just sitting there all day, as everyone knows.
And then once you establish the medical and you establish the occupational, how important is a personal statement, statements from coworkers, statement from family members?
The thing about these ERISA laws that govern these claims is that the one thing they did was they took away testimony. If you have to file a lawsuit, you're never going to be afforded the opportunity to testify in front of the judge. The judge can hear out of your voice what you suffer from on a daily basis, what your life was before your disabling conditions, what your life was while out on disability, what your life has been since you've been denied disability benefits. And the judge will never be able to hear from your friends and family and coworkers who've seen you suffer over the years. So writing personal impact statements is the only time that you're going to actually be able to testify to the judge. It's going to be in the claim file. If we submit it with the appeal, it's going to be in the claim file, and it's the only time the judge is ever going to be able to see what your own thoughts are, what your family's thoughts are. So essentially, it's your only time you're going to be able to testify for your claim. So it's very important for the judge to be able to see it, because the judge has to review it. If it's in the claim file, the judge has to review it. So it's so important to do personal impact statements.
And in some of our claims, we'll also want to do a recorded statement of the claimant or have them do a video of themselves showing what's wrong, sending pictures in of whatever the potential condition would be, especially if someone has physical manifestations of their condition. And doing these videos that we work with people to produce to show, like, this is my testimony, this is my statement, to humanize what's going on, with the claimant, because they only look at your claim on paper.
Right.
So you have this calculated effort of you got to put in the medical, which is we minimize it here, but it's a tremendous task to get that medical done appropriately. A lot of doctors don't want to cooperate, and we're very good at working with them, and if not them, getting the appropriate expert. Working on putting in your occupational description, through working with an occupational expert if we need one, or putting in our own, occupational study from studies that have been done about the occupation, case studies about the occupation. Again, also in the medical, we'll put in tons of medical literature to show how people who have this condition have difficulty returning to work. And the last thing is the personal statements from you, from friends, from family, from employees, and then putting this all together. You have everything. Now, why do people want to tell the insurance company what they did wrong in the appeal, and do you agree with that?
Why do people want to tell the insurance company? because they think that just telling them what they did wrong, oh, you got my claim wrong, please review, filing this appeal, obviously you got the decision outcome wrong because I can't work anymore, and they think that's enough. You have to go beyond that. You have to prove it to them that you're disabled. Knowing that you're disabled is not enough. You have to prove to the insurance company that you're unable to perform the duties of your own occupation or any occupation, and you do that with the medical records, you do that with the physician support, you do that with the personal impact statements, and you do that by tearing apart the reviews that the insurance company is relying upon. You can't just say, I appeal. I see so many times where people come to me to file a lawsuit for them, and they did their own appeal. I took a look at their appeal, and their appeal is literally 3 lines long.
Right.
And I do the best I can with the lawsuit, but their lawsuit is nowhere near as strong as a lawsuit of an appeal that I filed.
And then the last thing is we want to really make sure they're prepared if you lose, that you have the best possible chance of winning in a lawsuit. So we want them to review all of the new evidence, but at the same time, we're not going to give them the roadmap as to how to evaluate the claim appropriately, because the standard review is, did the company act unreasonably? Not did they get it wrong, but was it unreasonable? And if we give them a roadmap as to how to do everything right, like many lawyers do when they submit appeals, those appeals might look good to a layman who's reading them, but they're terrible. And I bet you those lawyers don't win a lot of those appeals. You can't give them the roadmap. So let's talk about your claim with Reliance Standard. If you need to file an appeal, please call Alex or myself or any of our disability lawyers. We help claimants all over the country. We always offer you a free initial consultation and review of your claim denial, and we look forward to the opportunity to speak with you.